Moving to our next panel discussion, which explores bilateral investment strategies, India and US, from setting up subsidiaries and navigating legal frameworks to understanding policy changes and trade impacts. Please join me in welcoming our distinguished panelist, Honorable Judge Jennifer Choe-Groves, United States Court of International Trade, New York, Mr. Vikas Varma, Partner, Crush and Varma Law Group, Ms. Lauri O'Callaghan, Associate, Rooney Law, and Ms. Meaghan Doyle, of Counsel, Crush and Varma Law Group.
All right, good afternoon. Thank you so much for the invitation to be here. First of all, I'd just like to thank the Ambassador, the Consulate General of India, IIAC, and Draft and Craft for inviting me and organizing this wonderful conference. It's an honor to be here, and I'll just give you a quick background about myself. I am a judge on the U.S. Court of International Trade. You may have heard about us. We're in the news. We've been in the news lately, involved in the Trump tariffs. So that is something that my court has been involved in, well, for decades, really, that we've been doing tariff cases. But we've been especially busy in the past 8 years or so. So I started out in New York as a prosecutor. I was at the Manhattan DA's office to start, and then I was in private practice, specializing in intellectual property. So I found your remarks very interesting, very close to my heart. And then I left private practice, went to the White House, and worked under both President George W. Bush and under President Obama, doing intellectual property, in particular, negotiating free trade agreements around the world. So I specifically negotiated intellectual property chapters, so involving every aspect: copyrights, trademarks, trade secrets, patents, pharmaceutical data protection, enforcement, transparency, all in the intellectual property sphere, all across Asia, Europe, Africa, the North and South America. And also I worked on the Special 301 report. You may be familiar with that. India has been a long time focus of attention of the United States and intellectual property matters. So I worked on Section 301 and Special 301, and then I've been on the court now for 10 years. And it's a lifetime appointment, and we have national jurisdiction over international trade and customs matters. So one of the cases that I worked on was involving intellectual property. Specifically, during President Trump's first term, he put the 25% tariffs on China for intellectual property violations under Section 301. So there was a 3-judge panel for that. I was one of the 3 judges. And the wheels of justice turned very slowly because those tariffs were imposed in 2018. We issued our decision in 2023, and it was just affirmed by the Court of Appeals last month. So it's taken a very, very long time, and it's probably heading to the Supreme Court. And then, of course, you've heard about the IEEPA case involving the tariffs. That's going to the Supreme Court next week. So I'm also very interested, like you are, to see what happens with that case. And so another issue that came up earlier is I sit by designation in other district courts. So, for example, I sit in Delaware. I do a lot of patent cases there. So I was very interested to hear the discussion about Delaware and Texas. I've litigated patent cases in Texas. I also am familiar with Nevada, and we can certainly have a discussion with the panel about more of those issues from earlier. I thought that was an interesting discussion, and it didn't touch on some of the issues that I thought were important. And just wanted to set the stage for our discussion today. There's a lot going on, obviously, between the US and India in terms of international trade. We know that there were 50% tariffs put on India last August by the president, and we've talked earlier about geopolitical issues here, and you really can't separate international trade and intellectual property and the geopolitical, it's all intertwined, which is why I find this area of the law very fascinating. And so I hear that there are good discussions going on right now. I do understand that there was supposed to be a meeting, I think, between Prime Minister Modi and President Trump over last weekend that did not happen. But I am reading in the news that the discussions are promising and they're hoping to reach a deal. And the idea is that the tariffs will go down to 15% on India if a bilateral agreement is worked out. And I understand that Russian oil is front and center in those discussions. And so, I think I'm optimistic. I always try to be optimistic in these. I know that both the U.S. is very interested in opening markets to agriculture and other U.S. products going into India. And then I know India is very interested, obviously, in opening markets in the U.S. to pharmaceuticals and textiles and all of the other manufacturing industries that are important in India. So I guess that sets the stage, and I'll turn to, we'll turn to now Mr. Varma, who introduced himself, Vikas Varma, as VV or V squared. So I'll turn to him now. Please come on up.
Thank you, Judge. It was lovely. Atul left the room. I think he did that to make it comfortable for me. He was my ex-boss. So it's always difficult to speak, in front of your ex-boss. So he thought. In the first session, we heard from Atul and Rakesh regarding investments in India, the legal and the regulatory infrastructure offered by India. And we also heard from Eileen regarding the processes for cross-border investment, do's and don'ts of dispute resolution. I would like to thank Eileen, Rakesh, and Atul for the lovely, informative presentations. Ours will be more of a panel discussion. But I would like to set the stage by sharing few facts and information about investments by Indian businesses on the US side. $40 billion. That's a number I want you to hold in your head while you're hearing these facts. Everybody assume it's one-way street. Always India getting FDI from US, but tables have turned, and we'll talk about that. Historically, the predominant model of India-US cross-border transaction has been outsourcing of information technology and information technology-related services to India and other several back office operations like financial services and all whatnot. However, in the last few years, there has been a strategic shift. And now Indian companies and their owners especially are establishing US entities and subsidiaries in manufacturing, life sciences, healthcare, engineering, R&D, consumer goods, and even space and advanced tech. $40 billion is the investment that has been made till date by privately held Indian entities into US subsidiaries or US operations. I understand that's a small number compared to the $900 billion number that has been made from US into the Indian side, but hey, $40 billion is no chump change. A recent survey by Confederation of Indian Industries shows that the following four sectors on the top of the US-bound investment from India: life sciences and pharma at 29%, telecom at 21%, manufacturing 18%, and services at 10%. Hey, if I were given a poll here, you guys would have thought services is at the top, probably 50% to 51%. That is only 10% of the market. 29% is life sciences and pharma. We had a lot of discussion about which state to pick up for formation, Delaware. In fact, Texas, New York, New Jersey, and California are the four leading states where Indian entities invest and incorporate their businesses. The reason is twofold. I will talk more about it. The whole discussion about which is the better jurisdiction, which has better laws, is all about corporate side of it, the corporate governance you're talking about, shareholders dispute, international disputes. But what about the operations itself? If you're going to establish a headquarters in California and hire 100 employees there, it does not matter where you're incorporated because all your business dispute, all your employment disputes are automatically going to get litigated in California anyway. And you will be registering in California. So why first incorporate in Delaware and then go again to California to re-register and do a business there? We'll talk about more. And it's no surprise that these are the 4 states with the most dense Indian population. So investment credits and tax credits for investments made in the startup businesses in that state. And if you're not incorporated there, if you're not located there, you'll not get that benefit. Tax treaty benefits, and very importantly, protection of intellectual property. We will also talk about the structure, C Corp versus LLCs versus S Corp. We'll jump into that. With that, I think we set the stage, and Atul is back. So we'll sit down and have a panel discussion.
Lauri, okay. So I guess we'll start with Lauri. So what do you think are the most significant legal trends these days in your work? Give a introduction to yourself, please.
This working? Yeah. Hi, I'm Lauri. I'm an associate at Rooney Law. I typically just kind of like help companies set up over here. I'm not really sure about
You're gonna have to
legal
speak up.
trends. Is it on?
Yeah, I think it's on. Just speak up.
Just tell me. Counsel.
Yeah, counsel, please.
Sorry.
Keep your voice up.
I'm not really sure about legal.
What kind of work do you do?
We are a small firm. We help companies kind of land and expand in the U.S. is what we kind of say. So typically foreign companies looking to set up over here, we do everything from the incorporation, registering their IP, helping employees over here. So just all the kind of setup and getting them ready to go.
Okay. And do you have a view on Delaware, Texas, Nevada, California, New York, in terms of incorporating?
Yeah, we typically do see mostly Delaware for the reasons a lot of people already said today. It really does depend on the situation. There's sometimes when, if it's just going to be one foreign owner of the company, like a UK parent entity or anything, and it's just going to do operations in New York, it doesn't necessarily make sense to be doing 2 state registries every year and all of that. So it's really situational. Obviously, if you're going to be taking on investors or anything like that, Delaware is the main place to be, but yeah.
Okay. Ms. Doyle, do you want to give an introduction and talk about some of the legal trends that you're seeing in your work?
Sure. So I'm Meaghan Doyle. I am an intellectual property attorney in Orange County, New York, and I've primarily worked in very tiny firms with very tiny clients. I am of counsel to Craft Varma, so I work with Vikas regularly. He does a lot more of the business type of thing, and then when he has intellectual property needs, he loops me in, and I do, again, primarily filing of trademarks, patents, copyrights, the more of the prosecution of those items, not so much the litigation. So.
Is it on? Can you hear me? Yeah. I would like to add that we have started, in fact, doing some of the litigation on the trademark infringement. We had a very interesting case right now where it involved cyber squatting by, we don't know the origin of the business, but it was definitely not US located. They took a domain which was very similar to our client's domain and copied the website and had their own phone numbers, basically using all the credit card information of the people who go to this spoofed up website. So we started a WIPO action and we took over their domain for free. Basically, we claimed that, hey, this is being used for criminal activities and there's no way these people should be allowed to use this domain, which is very similar to our domain. And WIPO agreed with us and handed over the domain to us. Sorry, I didn't give my introduction as to what our firms do. We are a very small firm. For the last 18 years, we have been helping businesses abroad to come to US. We help them start up and set up their business in US, and we act as their general counsels. Anywhere from $500,000 to $25 million is our sweet spot. And once they become too big, obviously they move on or an IPO. But we are representing mostly clients who are high net worth individuals, privately owning the business or a small group of investors. And we act as their general counsels right from their setup, their leasing, their intellectual property issues, contracts, leasing, whatever they need.
So I wanted to go back and talk a little bit about the differences in jurisdiction and some of the pros and cons about whether you want to be litigating in Delaware or Texas or Nevada or New York, for example, or even California. So as I mentioned, I sit by designation, so I do a lot of IP litigation in Delaware. One thing I would say about Delaware is that there's only 4 judges there. And so it's very predictable. It's easy to know how you think they're going to rule because for the most part, they've all been there for years. There's a history there. And, you know, I'm very cognizant when I sit in Delaware that I follow the Delaware rules, and I try to also be predictable following the Delaware laws and the Delaware rules. I will say, and the juries also, I find to be quite reasonable, and they have also, the juries understand their role as following the law. I would say I've litigated in Texas. I'm very familiar with a lot of the judges in Texas. I would say as a general rule, if you represent a foreign company, it's not a friendly jurisdiction. You don't want to be in front of a Texas jury if you are representing an Indian company, for example. I've seen billions of dollars of judgments coming out of juries in Texas. There's a real, I think, much more so, I think, than Delaware, there's a distrust of foreign companies. And so I think if you are sued there, you're at a disadvantage, and I would think you would want to try to move your venue to a place like Delaware. And again, the courts are looking at place of incorporation as the main indicia of where the litigation should take place, more than where a business is operating. And so, you know, and I'll just say anecdotally, in Nevada, I've heard that there's been, because a lot of companies are gravitating towards incorporating in Nevada these days, there's a lot more patent litigation happening in Nevada, and those judges have never seen patent litigation before. And so you're not getting the knowledgeable judges and juries and people who are adept at handling these very sophisticated types of cases and legal issues. And even in New York, there's a lot of judges in New York, in both the Southern District of New York and EDNY in the Eastern District. But by and large, IP litigation is not their bread and butter. That's not what they do there. And so, again, I think as opposed to a place like Delaware, that is their bread and butter. All of those judges have IP backgrounds, and they're used to this. I would say that a lot of the judges in Texas also have IP backgrounds, but as I mentioned, it's not necessarily very friendly to foreign companies. I don't know if you have other thoughts.
Yes, I would like to that. You have to draw a real distinction between your operational location versus your incorporation state for jurisdictional issues. You can incorporate in Delaware and say, oh, I'm subject to Delaware law. But if your headquarters is in California and you have 100 employees there and you're operating out of there, it's your lucky day if judge hears that you're not subject to a California law. They will draw everything in their arsenal to claim long-arm jurisdiction and say, even though your contract says you are subject to Delaware law, even if you are incorporated in Delaware law, they will try to pull you in California, and California will definitely like to pull you in. And specifically with the employment issues, it does not matter. If the employee is located in California, you're subject to California law. Just thanks for bringing so much the Nevada discussion. Nevada is a short-sighted situation. People are running to Nevada because it's a tax-free state. The owners think, oh, I'm not going to pay tax on my income. If my business is located here, I'm going to save on my income tax, that whatever 5-6% of the state tax. I believe that's a very short-sighted planning, because Nevada does not have that well-established laws or precedents. And I always tell my clients, hey, this should be your sliding scale. First, where are you going to operate out of? How many employees are you going to have? Are you just an online company? Are you just going to operate as a branch office? All these things play into it. There is no yardstick. You can just say that, hey, I check these 3 boxes. I'm in Delaware, or I'm in California, or I'm in New York. I'm seeing so much of incorporation in New Jersey these days, which was non-existent. Who used to incorporate in New Jersey? No one. I mean, like it's New York or Delaware or California, Texas even, but nobody used to incorporate a business in New Jersey. But now a lot of incorporations are having in New Jersey. The reason being, a lot of high net worth individuals established their home base in New Jersey, and they want to have their offices and business in New Jersey. But why do I have to register in another state and then in this state as well, subject to dual taxation? They just went ahead with New Jersey these days.
Well, and then to follow on, what they're seeing in the courts in New Jersey is now all of a sudden they're starting to get a lot of high-tech and patent litigation in New Jersey, and those judges aren't equipped or trained in those areas either. So for the first time, they're starting to, in particular, seeing a lot of pharmaceutical patent cases. So they've actually reached out to me to come help in New Jersey to start hearing pharmaceutical cases, which I'm probably going to be doing soon, because they just don't have the expertise.
Yeah, I remember we helped a couple of pharmaceutical companies come and establish their operations in New Jersey. In fact, like really the border of New York, New Jersey, Bergen County kind of area. And they were all Delaware entities, but their headquarters, their R&D, their employment, everything is in New Jersey. So even though they tried that, oh, we are a Delaware corporation, the court said no, for all purposes other than the contracts in which you can argue, like basically any shareholders action kind of thing, you are a New Jersey entity. The other thing I have seen is financing. If you're getting a loan, let's say hypothetically from the 3 big banks in US, it does not matter where you incorporated. Their loan documents will be governed by New York law. They don't even sometimes take even Delaware law, but they just want New York law. So these are the nuances. From a 10-mile view, you can decide, oh, everybody talks about Delaware, let's go Delaware. Oh, California is where the Silicon Hub is. Oh, Texas and Nevada is tax-free. No, it's more complicated than that. Somebody has to do a deep down analysis and help you understand that. And that's what we have done. I mean, like we have clients who have manufacturing operations in 4 states. And earlier we used to establish them in Delaware as the operating entity, real estate holding entity in that particular state. But in last 2 years, we have changed the model. It's like, why do we need Delaware and then a second registration in the local state when your 100% of the operations in manufacturing are going to be located in that state? And you are owned by, you're singly owned entity. So you're not going to have a shareholders dispute ever. You are just talking about your operational issues. So just stay to the state, whichever state you are, and whether it's Illinois, and I'm talking from real example, Illinois, New York, Texas, and Connecticut. That's are the 4 states that business is operating as a manufacturing unit. And that's where they're incorporated, except for one holding company which we kept in Delaware for the financing purposes.
Why don't we open this up to the audience and we can have a discussion? Yes, please. I think they're going to bring you. Are you going to bring the microphone?
We can lend one of us. We can share.
Got it.
Mr. Varma, I can understand. You mentioned a couple of times California. From employment law point of view, California, I can understand because it's very pro-employees. But we are missing here one point, that is a choice of law in the contract. So isn't that more important than just we are discussing Nevada, this, that? If the contract says that choice of laws will be state of, let's say, Texas, and the jurisdiction will be Delaware, then I don't understand then where California comes in the picture. So that's one question.
Let's answer them one by one. That would be a good idea. Have you ever litigated an employment dispute in California?
In California?
Yeah.
I'm not licensed in California, but
So
I know.
I will tell you, California is most ruthless, and this is my personal example over 15, 16 years, representing several clients out of California. I'm licensed in New York and California. There's a reason because of that. And they can literally run you to the ground, like finish you off in the employment litigation. It does not matter what contract you have with the employee, what kind of dispute is. Juries give such obnoxious awards in California against employers that make your head spin in 1 minute, like what just happened? And this is a real thing. You're talking about millions of dollars for most insignificant things. So that's what I'm saying. You have to be very, very careful what you're talking about as to picking up a jurisdiction. If you are a heavily employee-based business, you do not, I will not say you should not. I mean, that's your decision. But you should be careful before setting up a shop in California or some of not so employer-friendly states.
So that's what I'm saying. The California is very pro-employees, not pro-employer.
100%
So
employees.
if you see non-disclosure agreements, they are basically not enforceable in California. So why any employer would pick up California state's choice of laws in a contract, especially if it is an employment contract?
Yeah, so I'm not talking about choice of law because that's a different thing. I mean, if you're talking about employee issues and all, choice of law is kind of out anyway. You really do not give choice to the employee to have a choice of law, and the courts will look at that way. I mean, judge can probably, throw light on that. You throw the employment contracts as the employees sign it, and if you're going to argue tomorrow that I have a choice of law that we will litigate this case in New York or Delaware because we are incorporated there, and even though you are located in that state and you're providing services in California, you're not going to win. You are not going to win that argument. Secondly, so that's the employee issues. The reason you're going to still incorporate in California and be present there is because of the business. Everything gets trumped by business requirements. And if you have to have the infrastructure in that area, your workforce and everything, you will take that risk. I mean, I'm talking about practical purposes. This is really that has happened. Even though employers understand the risk, they still go to California, they still work out of there because they need that infrastructure. They need that environment.
Yeah, but that problem can be, let's say, for example, the employer is based in New York, it's a New York incorporated business, but the employee is posted in California. The employee will say, I am subject to jurisdiction of California because I am based in California. My employer has transferred me to California.
Absolutely right. I agree with you. That's what the position is. That's what I'm saying. The whole discussion of choice of law does not apply in these situations.
No, I'm saying in contract, in other areas, you can have a choice of law and you can have a jurisdiction point of view. You can pick up the venue also. That venue of litigation will be XYZ state, choice of law will be of ABC state, and one party is in California, the other party is in Texas, and litigation can be take place in New York, a third neutral state.
Yeah, I think we're talking about venue versus choice of law. Venue can definitely be issue there.
You can have both in the contract.
Yeah, when you have an independent party contracts, that's a different thing. There's your choice of law and choice of contract when it talking about contractual situations. Remember, there's also exceptions for the product liability and all whatnot. If you know your product is going to be sold in that state, you again get subject to that state and all whatnot.
Yes. In fact,
that does not affect your choice of jurisdiction for the incorporation. That's more of a choice of law as per your contracts.
But for incorporation also, I will look into the statute of limitation also, which particular state is giving me much better statute of limitation. Thank you.
Let's take a question in front then.
Hi, I think I just want to clarify something. I think what you were trying to say earlier is there's a clear distinction between operational place of business and incorporated place of business, right? The reason why you incorporate in Delaware is because, one, it's investor friendly. We know all safe notes, be it the difference between preferred common, the fiduciary duties, all of the challenges or acquisitions, anything that any founder may face is very well established in Delaware, which is why primary reason I think most lawyers in this room or anyone who works in corporate segment knows that we choose to incorporate in Delaware. And I think the operational aspect is, of course, where you're planning to set up your company, where you're planning to have most sales first. All of that depends on exactly the area of sector that you're working in, be it California, Texas, New York, right? So is that the correct clarification?
That's a very good articulation of that. One thing I would also like to add is startup businesses looking for investment. You started your conversation with the investors.
Yeah.
And we are talking about, to some extent, also foreign businesses setting up their subsidiaries here. They do not have safe notes, they do not have investor relations, everything is local. All they are doing is transferring money here, setting up business here, selling product here, selling services here, doing R&D, going back. They have none of those issues or a corporate governance issue. They can literally form in Illinois, they can form in North Dakota, get their business done, and it will not make an iota of difference for them because they have very specific purpose. And that's, again, I'm circling back to the same point. There is no one box for everyone exactly for that situation. We represent a lot of startups, and 99% Delaware. They're like, let's not reinvent, we tell our investors or the clients, let's not reinvent the wheel, spend 2 hours discussing which state has benefits or not. If you're starting up, you're looking for investors, it is going to be a C Corp in Delaware, open and shut. No need to spend 2 hours of legal time to come to this point again after 2 hours of discussion. I'm telling you, this is where you're going to end up. That's what.
How about in the back? You have a microphone.
Yes, Judge, this is a question for you. What's the status of Foreign Corrupt Practices Act? I mean, since we're talking about bilateral investments, I mean, I'm kind of very one of those murky areas. Is it a prosecutorial discretion not enforcing the laws, or have they suspended it? I don't think the Foreign Corrupt Practices Act is suspended. I'm just curious to know about
I'm
it.
actually not sure. That's outside my area.
Yeah.
So the question is, if the FCPA is being enforced right now, I don't know if it's been suspended or not. So
All right.
is there an answer over here?
I obviously don't have an answer in the context of US law, but to answer your question about the FCPA, I think the recent issue with regard to taking jurisdiction against one of the big conglomerates in India has clearly set down the ground rules for extraterritorial application of FCPA, because in that case what had happened was that the text message or the WhatsApp message was sent through a server of Meta in US, and that's how the Department of Justice, usurped jurisdiction or decided to have jurisdiction. And so to that extent, at least that's something which I've missed out in my talk, is the cross-border application of FCPA, and therefore the relevance of compliance in the context of India-US businesses. We had an illustration of what, at least in the last 2 years, about 4 examples of Indian subsidiaries of US companies having issues under FCPA and the sanctions, because now the sanctions has taken center stage. So therefore, this is something which I believe is something which needs to be settled once and for all as to what is the scope of jurisdiction of DOJ in cross-border in infringements of FCPA. So far as the other aspect is concerned, the jurisdiction, I think I'm not an US expert, but I believe as it happened in the Union Carbide case, the Bhopal gas, the US court threw out the challenge, the claims for compensation out of US, because they said the cause of action arose in India. I thought they're two distinct, and my colleague here very clearly mentioned the distinction between an incorporation jurisdiction and the cause of action jurisdiction. So I think, Vikas, your point that, where does the cause of action arise? Where is the claim fructifying? And can you say that it's completely devoid because you're incorporated in some other jurisdiction? In the Indian law, of course, it's codified in Indian law. It's very clearly codified. It's where the defendant resides or where the cause of action arises. So you have the choice. So Vikas, and coming to your observation when you made earlier, there was a very strategic exit I made because I knew you were going to ask me a few questions. Thank you.
Yeah, and I think just on that point, choice of law is different than venue, and the court definitely takes into account choice of law provisions in the contracts, in the negotiated contracts. So, for example, a case may happen in New York, but if the parties have agreed that they're going to apply Nevada law, then sometimes the courts will just apply Nevada law in a New York court. And that happens all the time, because the courts will respect the contracted provisions that are in the original, not necessarily choice of forum. They might, or that is a venue question that's separate as well, and the courts might not necessarily honor choice of forum provision, but they will definitely take that into account. So I think there was another question.
I have
here
a
in
question.
front. Yeah.
Hi, Mr. Varma, it is for you. V Square. Mr. V Square, it is for you. Thing is, my name is Adi Narayan. I am from a Bharat Electronics company, which is a defense electronics company in India. We have a branch office in New York from 40 years. This branch office is basically, we are only doing a procurement activity for buying some components from original manufacturers from here and sending to India. But now we are exploring our business opportunities, and now we wanted to set up a subsidiary here wherein we can participate in defense contracts in US. Now my question is, now that subsidiary will be completely owned by our parent company in India. Now the question is, how is that parent company is protected in case of any disputes arising out of this subsidiary? The first question. Second question is, what is the advantage or disadvantages if we register in Delaware and operating in New York?
So you want a free advice, right? every lawyer,
This forum is for this only, probably.
every lawyer's nightmare. Okay, let's see. So, limited liability protection.
Send him your invoice.
Sorry?
Send him your invoice later on.
I know where Bell is, by the way. Yeah, I know.
Yes.
So limited liability protection is available as like 70% of the US lawyer if you comply with certain requirements. I'm not going to walk through all of them, but as long as you do the compliances, you have incorporated it separately, done it properly, there is no reason it should flow through to the parent, except when it becomes a political issue and now courts wants to find it. Courts can always find a reason to pierce the corporate veil when it has to be done. Union Carbide. When they never wanted to pay the money, they found a reason. Supreme Court is, if US, as everybody here understands, is also a law-making body. They do not just read the law and say, this is what the law is, sorry. They can pretty much lay down precedents and they say, as per the Constitution, as per this is what the law should be. This is what it should be done. So, if you being in such a strategic industry, if something happens and they want to pierce the corporate veil, they will pierce it. But your holding company is not subject to the jurisdiction of the US law and they do not have a presence here. So what are they going to do? The best they can do is freeze your accounts. They can take over the assets of the subsidiary. I don't know how they're going to handle that in India. I think that's where the Atul comes into the picture. You get a judgment against a subsidiary. Probably they're also going to implicate the holding as a defendant. They get now either the defendant will appear in the court and start defending. Once they start defending, now there's not going to be a default judgment. Now you have a real judgment. But what if they don't? They say, no, we are not subject to your jurisdiction. We are not present there. We are not doing business here. It's our subsidiaries doing business there. And they defend themselves and they'll lose the case. And there's a judgment against the subsidiary and a default judgment against the parent. We have to call it to figure it out. I don't know how it will be handled in the Indian courts.
That means it is parent company is completely protected?
A majority of it, but as I just started from, if the courts want to pierce the corporate veil for some policy reason, they can pierce it. Okay. If you are selling linen on Amazon, they're not going to pierce the corporate veil for that.
Okay.
But if you were selling missiles, I'm sure they will.
Okay.
I mean, that's my guess. My bet would be they will.
No, it is only in case of some disputes. Otherwise, I don't think selling will have some implications on that.
Yeah, and the kind of work you just projected, why will you have a liability that will go over to your holding company?
Okay.
You probably will have a claim against somebody, but why will somebody have a claim against you? unless you have a specific scenario where you envision a claim arising against you.
Yes.
So we have a
What was the
question,
second
we have a question behind you now.
Second question answered.
What was the second question?
That is, registering in Delaware and operating in New York. What are the advantages and disadvantages?
So in your situation, I will not suggest incorporating in Delaware because you do not have investors, you don't have safe notes, you don't have promissory notes, you don't have options. You are never going to have any shareholders action or a corporate dispute. It's like right pocket to left pocket. You're 100% owned by your holding. So wherever you're going to have business, just incorporate there. Keep the costs down.
Okay. Thank
We
you.
have a question behind.
Actually, I don't have a question, but I just wanted to comment on the earlier question. The foreign parent, in addition to being pulled in if there is a piercing of the corporate veil, it may get pulled in if parent company is the owner of the IP, or parent company happens to be exclusive licensee of the IP. We'll often see them pulled in along with the U.S. subsidiary in U.S. litigations. Thank you.
Did you want to add anything? Did you want to add anything? Okay. Well, let's go to somebody who hasn't asked a question yet. Okay, go ahead.
I have a question for you, Judge, because
Sure.
you mentioned in the beginning, in your opening remarks, about that you are very optimistic about India, USA having a trade deal and 15% tariff you mentioned. I'm optimistic, but as well as I'm very cautious also, considering the fact that right now India imposes 120% tariff on United States walnuts, 100% tariff on United States auto parts and automobiles, 39% tariff on United States agricultural goods, 150% tariff on United States whiskey. So in that particular situation, especially when India is not prepared to downsize its purchase of Russian oil, do you think that realistically we can achieve that 15% tariff, what you mentioned in your earlier comments?
Well, I would say, first of all, I don't do this anymore, so now I just read the newspapers like everybody else. I used to work at the White House doing these deals, and I would say, so the question is, would 15% tariffs be achievable if, well, the U.S. has 50% tariffs right now on all goods from India, and then India has 150% tariffs on whiskey and other U.S. Imported goods that are going from the U.S. into India. That's what the trade negotiators are doing right now, is they're sitting down with all of those items on the table, and everybody knows, the way this strategy works is everybody picks the most important things, so for the U.S. it's corn, it's soybean, it's whiskey from Kentucky, and for India it's maybe textiles and pharmaceuticals, as well as some other software areas. They know their pressure points, right? And that's what the negotiation is all about. And so I know they've been working certainly since, I believe it was in February when Prime Minister Modi came to the White House and they launched the negotiations. And it's probably taking longer than everybody would like, but from what I hear, they're making progress. And I think it's very important to the U.S. about the Russian oil, that India stops buying oil, because obviously the U.S.'s position is that helps to fund the Ukraine war. And so the U.S. is trying to get India to stop doing that. And it's all on the table, and I've been in those rooms. They work really, really late nights trying to come to agreement, and there's always, we used to say, you get a deal when everybody's unhappy. So when everybody has to give a little, that's when you get a deal. But so I'm just hearing that they're working through all of those pain points, but it's probably right now at its worst, I would imagine, in terms of trade relations and the pressure points between the U.S. and India right now. That's just my personal observation. So.
Thank you.
Are we at time? Okay, all right. Okay.
I'm going to thank all our panelists right now for such a rich and informative discussion on, bilateral investments and setting up subsidiaries and the whole jurisdiction issue. So thank you very much.